Okay, hello everyone. I think we'll give just a few more minutes here before we get started. All right, well, my clock reads noon, so we'll go ahead and get started. Hello, I'm Christina Di Filippo. I am an attorney here at Griswold, LaSalle, Cobb, Dowd Gin in Hanford. I'm here today to give a training on subpoenas. This is a big area, lots of nuance to it. So my goal here today is really to give a brief overview of subpoena practice and both in general, and I include some details on certain things that I feel are some of the more important things that we should be aware of. And if at any time you have a question for me, you can just put it in the chat box or the Q&A section in the chat. If I don't see it right away, I'll see it at the end and I'll answer any questions I haven't already. Also, just a quick housekeeping note, if you are pre-registered for this, you'll be getting a CLE certificate afterwards. If you're not pre-registered, that's fine. You just need to email Lane here at our office, and you can get a hold of her at marketing@griswoldlasalle.com, and I'll put that in the chat box as well. I've got a chat that someone's not getting audio. Is that everyone, or can someone tell me if they are getting audio? Okay, someone can hear me, so that's good. Okay, thank you. That I don't know, some people might not be able to hear me. If not, I'm sorry about that. Not that you can hear me say that. Okay, so we'll go ahead and get started. I'm going to bring my slides up on the screen. Okay, they should be up. Okay, so a brief guide to subpoenas. Christina Di Filippo, that's me here in Hanford. So what we're going to be covering today is general subpoena provisions, what to include in subpoenas, timings that are associated with these, and then special requirements as they relate to consumers and employees. We'll cover that as well, and responding to subpoenas. So subpoenas in general, we're going to start there. What is a subpoena? Is a court order compelling someone or some business entity to do something or to provide something, whether that be documents or things. That's in connection to a lawsuit. So you could be compelling someone to appear at a hearing or a deposition, or to produce documents, produce things, and that could be at a deposition or a hearing, or a combination of both. You could be compelled to appear and also bring things with you when you appear. Generally, subpoenas are being used by attorneys and parties to gather information, or make you appear somewhere, make you be somewhere that they want you to be. So there's the different types of subpoenas. I think of them in two separate categories, so I kind of did the columns. This is just how I think of it. It may not be for everyone, but I think of subpoenas in one category being relating to trials or hearings, and another category being relating to depositions. So something for trial or hearing and something for the discovery process. So in the left-hand column, we've got the relating to trial or hearings. So we've got subpoenas for personal appearance. So we want you to show up to court to answer questions. We've got subpoenas requiring production of documents. We want you to give us these documents, and that could be providing these trial documents, or it could be requiring you to show up at trial and also bring documents with you. That's the different types. And then moving to the right, relating to depositions. So this would be before a trial or hearing. So deposition subpoenas, requiring a non-party to provide documents or records and or appearing to answer questions at a deposition. So just below there, I've got kind of the subcategories, how I think of it. You've got deposition subpoenas just for personal appearance. You know, we want you to show up for a deposition. We're going to ask you questions on this day at this time. Or we've got subpoenas for production of documents. We want you to give us these documents. We don't need to see you. We don't need to ask you questions. You just need to give us these documents by a certain date. Or we've got subpoenas for both, a combination of the two. We want you to show up for a deposition so we can ask you questions, and we also want you to bring these documents with you. And then I have just a little note there at the bottom that some agencies, DMV, workers' compensation companies, they have their own subpoena forms and processes. So just to be aware of that if that comes up. So for non-party witnesses, in California, deposition subpoenas are necessary to compel someone who's not a part of this lawsuit to do something or to give something. These are people that are not parties. They have no real interest in this case other than whatever information they have. So in order to get that information, you need to issue a deposition subpoena. This is the only way to get that information from a non-party in a civil litigation. We've kind of gone through this, but I just listed the 4 types of deposition subpoenas that could be served on non-parties. So as I said, you could have an oral deposition, which is we want you to show up and answer questions. We could have a deposition subpoena only for documents. Again, we don't need to ask you questions. We just want you to provide these documents. There could be a subpoena for records and oral testimony. So we want you to show up to answer questions and also bring these documents with you. Or a subpoena just for a written deposition. So we're going to ask you questions and you're going to submit your answers written. We don't need you to show up. That's the 4th type. So I just want to talk a little bit about non-parties relating to jurisdiction. So California residents, they are subject to California orders from a California court. They're within the jurisdiction of California courts. Where we run into a problem is non-California residents. If we're sending a subpoena to someone that doesn't live in California, that could be an issue. So generally, residents of one state are not required to appear in another state or provide records to another state pursuant to a California subpoena. They're not compelled by California courts to do anything. So in order to get these non-residents to provide these documents or to be compelled to do so, you would need to work with whatever state that person is in, the courts in that state, and that state court would need to compel them to comply with the California subpoena. Each state kind of has their own ways of doing things, their own procedures, so you need to find out what the procedure is in that state and abide by whatever the rules are in that state. Okay, so who can issue a subpoena, excuse me. A party is the short answer. A party in the lawsuit can issue or request a subpoena. According to CCP, as I have on there, the subpoena can be issued by a clerk of court where the action is pending, that's an option, or an attorney of record for each party. So it doesn't require a signature by a judge or clerk if it's being issued by an attorney of record. Okay, so now we're going to get a little bit more into the nitty-gritty, more specifics on subpoenas. Again, it's a big subject, so I tried to narrow it down as much as I could. So bear with me. Okay, so what needs to be included with a subpoena for appearance or production at a trial or hearing? Now, if you remember, I said I put them in two categories. Subpoenas related to trials and hearings, and subpoenas related to depositions. Right now, I'm focusing on the left side, the subpoenas dealing with appearing in a court or trial, or a production to a court or trial. So subpoenaing a non-party witness just to appear at a trial or a hearing, things that need to be included in that subpoena would be obviously the time and place to appear, and also you need to include that notice that I have on there, word for word. It's in the CCP just like that, at section 90 or 1985.2, and it says the notice must say, contact the attorney requesting the subpoena listed above before the date on which you are required to be in court. If you have any questions about the time or date for your appearance, is what it's supposed to say, or if you want to be certain of your presence, it's required. So that notice needs to be on the subpoena. If the subpoena requests documents to bring, then you have some additional requirements as well. So if you're required to bring documents to court or to provide documents to the court, that subpoena needs to describe those documents being requested with particularity. It needs to describe exactly what you're being required to produce. It also needs to include an affidavit showing good cause for the production of the matters. So basically, the person requesting these documents needs to tell you exactly what documents they're looking for, and also why, what the relevancy of these documents are, or how they connect to this lawsuit. And that you can find in the CCP as well. Throughout, I've listed the CCP code sections. That's mainly just so you know where I'm getting my information, and for you to look up if you need to later. Okay, so we're going to move on now to the right column, the deposition subpoenas. So these are subpoenas that are related more to discovery. This is not related to trials. This is related to depositions. So if the deposition subpoena is commanding only the appearance of the deponent, we're only asking you to come and answer questions for us. The subpoena needs to include a specific time and place for the deposition. It needs to give a summary of the deposition, including the deponent rights. And included in that would be things like whether the deposition will be video recorded or audio recorded, if there will be a stenographer there, just kind of the specifics of what the deposition will entail. And if the organization is, or if the deponent is an organization, excuse me, you need to describe the matters relating to the examination. So if there's a deponent coming and they are related to an organization, you need to be a little bit more specific about what questions you're going to be asking, or the topics in which you're going to be asking questions about. Okay, moving to the next one. So if you're commanding document production, either with or without personal appearance, if the subpoena is asking for documents, then there's some requirements as well. So again, obviously time and place for appearance and production. You need a date. We need the documents by this date. We need you to appear on this date. Again, you need to have that same summary of the nature of the deposition. If they're being required to appear as well as bring documents, again, you need to tell them if it's going to be recorded, if it's going to be audio or video recorded, or both. If it's going to be, they're going to be a stenographer, if just the specifics of the deposition need to be in there. And so you're asking for documents, so you need to also designate the documents you're asking for. You need to describe them in some sort of particularity, or describe the category of documents that you're looking for. And that could depend on the situation. Essentially, they need to know what documents you're really looking for. You can't just say all documents related to some broad topic, because they're going to come back with possibly thousands and thousands of documents, and that may or may not be exactly what you're looking for. Also, just a note there's no affidavit needed in this case, whereas with the documents being produced in a trial or hearing setting, there was the affidavit requirement. If it's for deposition, there is not that affidavit requirement. So this is something that I think it's overlooked a lot, and I wanted to bring attention to it. So when you've got a deposition subpoena for business records only, no appearance for a deposition, the subpoena is purely for the production of business records. That subpoena needs to include a designated deposition officer to whom the records are being provided. So that deposition officer cannot be financially interested in the action, or a relative or employee of the attorney in the action, or the party in the action. Essentially, what we're dealing with here is we're asking only for documents. We're not asking for anything else. So if the attorney is listed on there saying, okay, send the documents to me, the problem there is that there's no way of knowing that this attorney is going to give all of the documents they received to all the other parties. Ethically, of course, that it's required, but, safeguards are put in place such as this to make sure no funny business happens. So a deposition officer is going to be receiving those documents instead, and that deposition officer will then be responsible for giving out those documents to all parties. This is not true if there's going to be a personal appearance. If there's going to be a deposition, an in-person deposition, and you're being asked to bring documents to that deposition, you're just bringing those documents to your deposition. So the deposition officer is not required to get those documents in that case, because everybody's there, everybody sees what's being brought. The chances of funny business is not there. So I just wanted to include a little bit of an example. So this is a business records subpoena, and so I put yellow boxes. So deposition subpoena for production of business records only. And in the second yellow box, you see that the name of the deposition officer needs to go there, which in this case was Speedy Copy. What cannot be there is the attorney of record or the party requesting. That needs to be where the deposition officer goes. And also has other things labeled that might be helpful that you can look at. Okay, so moving on to timing. This is a little bit vague, but we're going to try and narrow it down a bit. So if a subpoena is for personal appearance at a trial or hearing, on my left column, then that person being subpoenaed must be given reasonable time to travel and or produce documents. So that reasonable time is vague, but case law has determined that reasonable time is generally 10 calendar days. Again, that may vary depending on circumstances, especially in situations like we're in now with COVID. That 10-day reasonable amount of time may shift. So just know that that reasonable time is not fixed, but it has normally been 10 days determined by the courts. So now moving to the right column, deposition subpoenas, a similar time frame. They must be given sufficient time in advance of a deposition to travel and or locate the documents being requested. And again, reasonable time is generally meant 10 days according to case law, but that is not fixed. It's not fixed in the code. It has been just determined in case law. So that may vary as well. If you're dealing with a deposition for business records only, no deposition appearance, that you must be give them 15 days to produce, and that is in the code. That 15-day requirement is in the code for deposition subpoenas for business records only. Okay, so service, everybody's favorite. Proper service of a subpoena. Personal service can be made by any person. That's in the code as well. Subpoena should be delivered to either the person being subpoenaed, the person named, or if it's an entity, it can be an officer, director, custodian of records, or any other authorized employee that's authorized to accept service. If the person is a minor, which does happen, that service can be made to parent, guardian, conservator, or some similar fiduciary. If none of those people are available or exist, service can be made to whoever takes care of the minor, not necessarily a guardian, but someone who takes care of them or who lives with them or employs the minor. At that point, if you still haven't found anybody that you can serve this to, and after due diligence, you can serve it directly to the minor if they're 12 years old. It's kind of a specific rule, but kind of worth knowing. Okay, witness fees. So their witnesses are entitled to fees per code. So current witness fees are $35 a day plus 20 cents per mile. So in both ways. So depending on how far they travel, that number fluctuates, obviously. So that's per code, that's what they're entitled to. For deposition subpoenas, the fee needs to be made with the subpoena or the notice, whether or not requested by the witness. The witness does not need to request witness fees to get them. They are automatically given to them at the forefront. For subpoenas dealing with trials and hearings, those witness fees must be requested by the witness, and so that's listed on there. There's the caveat for peace officers, firefighters, state employees, court employees, county employees. They are entitled to their full salary for any time that they're being subpoenaed as a witness. So then the subpoenaing party is then required to reimburse the employer, the public entity employer, $275 flat rate per day for that witness that's being subpoenaed. And that is per code as well. Any person or entity is also going to be entitled to reimbursement for document production in the form of per page costs for copying or printing, hourly clerical work if that was necessary, and postage. So any of those things are reimbursable as well. And exact prices for those are also per code. I didn't include them here mostly because I was running out of room on the slide, but those prices are listed in the code as well. Okay, subpoenas to parties in a lawsuit. So if you're a party in a lawsuit, you don't need to be subpoenaed in order to be compelled to do something or to show up. So no formal subpoenas are needed for any party in a lawsuit or any witnesses that are party affiliated. Those are generally officers, directors, employees, managing agents of a party. Just be careful that affiliation, that party affiliation, that affiliation needs to exist at the time of the deposition. So former employees or former managers of the party, they would require a subpoena because that affiliation does not exist at that time. So for parties and for party affiliated witnesses, you just need to serve a notice to attend or a notice to produce documents. And that would be 10 days before appearance, 20 days before an appearance if you're asking for documents as well. And that's per code, and that code is listed there as well. So I just have at the bottom, only need to serve a notice of deposition to compel an opposing party to appear, testify, or produce documents for a deposition. So both for showing up at trial and producing documents at trial and for depositions, only a notice is necessary for parties and party affiliated witnesses. Okay, so special requirements for consumer records from non-party witnesses. This is an important little caveat we need to talk about. So if you're subpoenaing consumer records, there are additional requirements, very important additional requirements. So just to kind of start out with some definitions, in this case, a witness as generally most healthcare providers, professionals, financial institutions, schools. So these are the people that are being subpoenaed for records, are these healthcare providers or financial institutions. The consumer is any individual, partnership, association, trust, who has transacted business with that witness, with that financial institution, with that healthcare provider. So it's the consumer of the witness. So before producing consumer records, so before that financial institution can produce any records of any of their consumers, a non-party witness needs to ensure that the subpoenaing party has done one of two things, has either provided them a written authorization from that consumer that it's okay to release these records, or proof of service, proof showing that that consumer was given notice of the subpoena going to the witness. One of those two things needs to be provided with the subpoena to the witness, the non-party witness. So that notice to consumer must be given at least 10 days prior to the production, plus additional time for if it's noticed by mail. Consumer must serve a written objection to release those records prior to the date of production. So if the consumer doesn't want those documents being produced, they need to serve a written objection saying, no, I do not agree to this, and this is why. So a non-party witness, that financial institution, can refuse to comply with the subpoena if they did not receive one of those two things, the written authorization or the proof of service to the consumer. They don't need to comply until one of those two things happen. So it's a little bit confusing, at least it was for me. So I did a little bit of an example here. So in this example, Paul is suing David for breach of contract, for lack of payment. David claims he paid the money years ago. Paul wants to subpoena David's bank to get his bank statements to see if the payment really was made years ago. So in this case, Paul would be the subpoenaing party. The bank is going to be the non-party witness being subpoenaed, and David is the consumer because David is the customer of the bank that the records relate to. So before that bank can produce those records, Paul, the subpoenaing party, must either get written authorization from David to obtain the records from the bank, or show that David has been provided notice of the subpoena that went to the bank. So if none of those things happen, the bank does not need to comply. As soon as that notice is given to David, David can object to the bank records being disclosed. Default. So I hope that makes it a little bit easier. Very similar for employee records, almost identical requirements, but it also applies to employee records. So just to go over this, an employee in this case would be any individual who has been employed by a witness or represented by a labor organization that is being subpoenaed. Employee records, they would consist of original copies or books or documents, writings, electronically stored information, anything pertaining to the employment of that employee, of an employee. So again, before producing any employee records, that non-party witness who's being subpoenaed must ensure that the subpoenaing party has included either that written authorization from the employee saying it's okay for these things to be disclosed, or two, a proof of service showing that the employee was given notice that the subpoena was sent to the employer. Notice to the employee must be given at least 10 days before date of production, again, plus additional time if it's by mail. And then the employee must serve objection to release those records prior to the date of production. So if they were given notice of the subpoena going to their former employer or their employer, and they just sit on it and they don't object, that's fine. They don't need to. The employer can still release them at that point because the employer did ensure that the employee was given notice. The employee did give notice. They just didn't object. So in this case, silence would be consent. And if you don't object, you're saying you're okay with it being released. So they do need to object. If they don't want those employee records out, they need to object. Non-party witness, again, they can refuse to comply if the subpoenaing party did not do one of those two things. So if they get the subpoena, if I'm an employer and I receive a subpoena for an employee record, and included in that subpoena is neither a written authorization from the employee nor a proof of service that that employee was given notice, I don't need to do anything until one of those things have happened. So another little example here, very similar to the previous example. Patty is suing Denise for breach of contract for lack of payment. Denise claims that she was laid off in June 2018 and has had no income since. Patty then wants to subpoena Denise's workplace to find out if that's true, if she was really laid off back in June. In this case, Patty would be the subpoenaing party. The workplace is the non-party witness being subpoenaed. Denise would be the employee. And now before the workplace can produce those records, Patty, the subpoenaing party, must either get written authorization from Denise to obtain those records or show that Denise has been notified, has been given proper notice of the subpoena that went to the workplace. At that point, again, Denise can serve written objections to those records being released, but if she doesn't serve objections and she was given proper notice, the workplace can release those records to Patty. Okay, moving on to responding to subpoenas. I guess at this point I can see if there's any questions. Oh, still that sound. I hope everybody has sound. Okay, I'll just keep going. If I can. So responding to subpoenas. So the methods, they include, you could comply with it. That's always an option, responding with whatever it is they want you to do or provide. You could file a motion to quash. You could serve written objections, or you can move for protective order. Those are kind of your main options when you get a subpoena. You have a choice to make. It's one of those. So motion to quash. You could be moving to quash it completely, to modify it in some way, or to qualify it in some way with terms or conditions. Any of that is possible. Motions to quash can be brought by parties to the lawsuit, a witness that's being subpoenaed, a consumer whose personal records are being subpoenaed. That's what we kind of just talked about. An employee whose employment records are being subpoenaed. We talked about those two situations. And also a non-party who's been served with business records. So anybody really could bring a motion to quash. These motions, though, must be served and noticed on the opposing party at least 5 days before the date of the appearance or the production date. So, you need to get that out. If you're planning on trying to get a motion to quash granted, that needs to be done at least 5 days before anything's supposed to happen. Okay, written objections. So the next option is you can serve written objections. When doing this, you need to be citing specific grounds on which the production of these records should be prohibited. So you need to be saying, this specific document, I'm objecting to this specific document being produced, and it's on this ground because of privacy issues, or because of privilege, or because of some other reason. But it needs to be specific to the documents. You can't just do a blanket objection to the production of these documents. These written objections can be brought by a party to the lawsuit. That needs to be within 5 days of receiving the subpoena. Third-party witnesses 3 days before deposition date. Consumers, we talked about that. Consumers whose personal records are being subpoenaed, they can serve written objections. Employees whose employment records are being subpoenaed, they can serve written objections as well. So any of those can serve written objections within the allotted time. Note the difference between the timing of the written objections for a party to the lawsuit versus a third-party witness. So just kind of pay attention. I put the code sections there, so if that comes up, you'll be able to find that quickly. Generally, third-party witnesses are given just a little bit more time to serve these written objections rather than a party to the lawsuit. Once objections have been received, no witness should be required to produce records until there's been some sort of resolution to it, whether that be an order from the court or an agreement by the parties. But if written objections have been served, everything sort of halts until things get figured out. And from there, the court makes a decision based on those objections, or many times parties get together and say, you know what, I don't really need that document. It's fine. We'll do without it, and it's a non-issue. Within 20 days of receiving the written objections, the subpoenaing party can bring a motion to enforce that subpoena, along with a declaration showing that they had reasonable good faith. They made an effort. They had a reasonable good faith effort at some sort of informal resolution to no avail. So if you get written objections or let me rephrase, if I receive written objections from a party to a subpoena that I sent out, within 20 days, I make an effort with them to resolve this. I really need this document, but I'm willing to accommodate you in this way, and I can't get a resolution with you. If I can show that I made a good faith effort to do so, I can then bring a motion to enforce that subpoena with the court, and then it's up to the court whether or not those documents are going to be produced. Okay, next would be a motion for a protective order. That's pretty much exactly what it sounds like. You want to protect this information from being disclosed. It can be brought by parties, non-parties. It must be accompanied with a meet and confer declaration per codes right there, showing again that the parties engaged in some sort of reasonable good faith effort to resolve the issue. Essentially, the court wants to know, did you try to resolve this, or are you just coming to me with this issue before we even see if there's a resolution? And the answer is you need to try to resolve it before you go to the judge. To defeat a motion for protective order, a subpoenaing party must show good cause for seeking that information, and that would be in a motion to compel. So, if someone motions for a protective order, the subpoenaing party needs to not only show that they tried to resolve this issue, but show that they really need this information and they have good cause to ask for this information. Okay, so subpoenaing party's response to subpoenaed party's response. So what do you do when you get written objections or when you get a protective order and it can't be resolved? Well, if the subpoenaing party still really wants that information, they need to file a motion to compel. And that would be made by the subpoenaing party in order to force that subpoenaed party to either appear or provide those documents, even over their objections. So the court is the one that decides, either grants or denies a motion to compel, and then enforces that. Again, that subpoenaed party must show they made a good, reasonable, fair effort to meet and confer and resolve the issues before filing. I just realized there's a typo. It should say subpoenaing party, not subpoenaed party. So if the party who wants the information still wants it and they're filing this motion to compel, they need to show, again, that they've made a good faith effort to try to resolve this issue before they bring it to the court in the form of the motion to compel. You need to show you did everything you could to avoid the judge getting involved. That's just required now. Okay, so I just wanted to do kind of a just very, very brief mention of the Public Records Act, mainly just to designate or differentiate that certain documents you don't need to subpoena to gain access to, and public records are those types of documents. So California Public Records Act says that any individual, corporation, partnership, limited liability company, firm, or association, both in California or out of California, it's not California specific to residents, they can inspect California public records. One can inspect all public records of government bodies that are covered under the California Public Records Act. And there are exceptions. I didn't list them here just for time purposes. But there are a number of exceptions, but for the most part, public records in general are you can inspect them, inspectable. Public records include, well, it's very broadly defined, as I kind of mentioned. It would include any information relating to conduct of public's business that is owned, prepared, used, retained by any state or local agency, regardless of the medium it's stored in. So it can be hard copies of records, plans, blueprints, things like that, contracts, or it could be electronically stored information. It could be photographs. It could be pretty much anything you can think of. If it's in the public domain, you have access to it without a subpoena. You just have to request it. So, as I said, there's no subpoena necessary in that case. So, upon request, public records, they're open to inspection at all times during the office hours of whatever state or local agency you're requesting these records from. Any reasonable portion of the record can be available for inspection by any person requesting it, after maybe necessary deletions for portions that are within those exceptions that I mentioned. So it's not a blanket, you can't see everything, but there's a good portion of it that you're going to be able to see. But the deleted portions will be deleted and you can look at everything else. But in terms of timing, a public agency has 10 days to provide a response to you on whether or not there are disclosable records that exist based on whatever it is that you request. And then after that, the agency has reasonable time to provide them to you. So if you go to a public agency and request all contracts with a certain entity or whatever it is that you're requesting, they don't need to give it to you right there, then and there. And some of that stuff may not be disclosable to you depending on the exceptions. So they have 10 days from that point to let you know whether or not there are documents or records that relate to whatever it is that you requested that are disclosable to you. They have 10 days to tell you whether or not they can disclose these documents to you, and if they have them, from that point on, they then have a reasonable amount of time to provide them to you. And that reasonable amount of time could vary. It depends on, how voluminous the records are that you are requesting. There could be, non-digitized records that they need to go through bankers' boxes full of documents to find these for you. So it could be a few weeks, it could be months. It just depends on the request itself. Also, just a little note that the code also allows the public agency an extension of that 10 days to respond to you, extension of an additional 14 days. And that's, again, related to, it depends on the request. If you're requesting something that it's going to take a while to even go through the records to let you know whether or not there are disclosable records, it could be more than 10 days. It just kind of depends on what it is you're looking for. One more time, no subpoena is needed to access these. You just need to go ask for them, and they'll let you know whether or not they've got disclosable documents that relate to whatever it is that you requested. Okay, I think that might be it. Yep, questions. So let me get to the chat box because I can't see it. Okay, first question, how do we get sound? I really hope that was fixed. Okay, so the question, no, as an attorney cannot be a deposition officer. No, an attorney of record cannot be a deposition officer. It needs to be someone that has no financial interest in the case, is not related to any of the attorneys or the parties. That's the only question I'm seeing on that. Let me check. Chat box. Oh, we've got a raising hand. Let's see if I can figure out how to. see here. So Audrey, you are asking for. Bear with me, everybody. I'm sorry, I'm new to this particular program. Okay, so Audrey, you are raising your hand. I think I can unmute you and you can ask the question. Are you still on the line with us, Audrey? No, okay, never mind. I'm just gonna go back to the chat box. If you have a question, if you raised your hand and you can type out whatever question that you had, please do so. Next question, if the attorney was doing pro bono, could they be a deposition officer? That is, I'm going to be honest with you, that's not specified in the code. My immediate answer would be no, because you still have an interest in the case and it's still dealing with the issue of making sure everybody is given the same information at the same time. So if you're receiving documents from a subpoenaed party as the attorney, there runs that risk of withholding certain things, or maybe withholding certain things for a little bit. So no, if you're just requesting documents, I would say it needs to go to a deposition officer, not even if it's pro bono. Okay, I think. Okay, so I got a question on the MCLE certificate. I'm going to put in the chat box right now as I'm doing this. If you were pre-registered for this MCLE training, then you will be receiving a certificate from Lane after this, after I sign off. If you are not pre-registered, totally fine. You just need to email Lane at this email that I am posting and let her know that you attended, and she will send you a certificate. So that email is going to be marketing@griswoldlasalle.com, and I just put it in the chat. Oh, I just saw another question. Once you have a protective order in place, can a party refuse or object to providing documents? Yes, if there is a protective order, then no one needs to provide documents until that's resolved, or there's another order that gets rid of that protective order. If I understood your question correctly. Okay, I don't think there's any other questions coming in. If there are further questions, you can feel free to email me. And that's going to be my last name, Griswold LaSalle, at griswoldlasalle.com, dfilippo@griswoldlasalle.com. Roxanne, did you get mine? Did you send a question? Oh, can we get a copy of your presentation? Yeah, we can send out the slides. I don't have a problem with that. We can send out the slides to anybody that that attended and is requesting them. That's fine. Just want to make sure I'm not missing a question. No? Okay. Thank you all very much. I hope that it was helpful in some way. I appreciate you listening to me for a full hour. And have a great day.